preparation that goes into trial is what really separates someone who knows what they're doing versus someone who doesn't. If you want to be successful as a lawyer at trial, you have to put in a lot of work ahead of time, being completely prepared on your facts. You need to know the facts of the case forwards and backwards. You want to have it as your goal as a trial lawyer that when you walk into court, you know the facts better than anyone. That includes the prosecutor, the judge, and even at times the investigating officer who was the one who initiated the criminal case. In addition to being prepared on the facts, you need to be prepared on the law. You need to know any particular law that might come up as exceptions that could come up at the spur of the moment in the middle of the trial. You have to have motions, legal motions prepared, fighting about what evidence comes in and which evidence fairly is kept out. You also need to be prepared with exhibits and have all of that stuff in advance. You also need to have experience when you're going into trial and know what you're doing. You don't want to be in a situation where you're attempting to defend someone on a case that you're really not qualified to do. I see that all the time with attorneys who are trying to gain experience at the expense of their client, and that's not fair to their client. An experienced defense attorney who knows what they're doing walks into court and they're confident that they're going to be able to do the very best job possible in representing their client. And that's a combination of not only their experience, not only their skill, but the preparation that they did leading up to that trial. Jury selection is really an art more than a science. I've worked with lots of different attorneys over the years. I had mentors 15, 17 years ago that taught me about some of the basic stuff as it relates to jury selection. There's some lawyers who don't even really try when it comes to jury selection, but the good litigators recognize that jury selection is a critical part of the entire trial, because ultimately that's your opportunity as a defense attorney, as a prosecutor, to pick the group of people who are going to decide what the facts are in the case. Each side in a criminal case, the prosecution and the defense, have a certain amount of preemptory challenges. Those are reasons why they can excuse prospective jurors off of the case. Some of those are for cause, and those are usually unlimited if they can show a particular juror has a bias, why they shouldn't be on the case. But then preemptory challenges allow each side, depending upon the severity of the case and the level of a felony, how much exposure someone might be facing, they have a certain amount of preemptories they can use for any reason. And as long as those preemptories are not being used for a discriminatory purpose, each side can do that in order to arrive at a group of jurors they think is best to try the case. Depending upon the type of case, an experienced defense attorney knows what type of jurors to try to pick and which ones to exclude. The jury selection process is also an opportunity for an experienced lawyer to kind of preempt some of the issues, some areas of evidence that they're concerned about. They want to gauge what jurors' reactions to that evidence will be. And so they introduce a little bit of information about the case in order to see how prospective jurors will respond to that and if they're still going to be able to give their client a fair chance. When we're talking about preparing witnesses for trial, we're not talking about coaching witnesses or telling them what to say, but we are trying to get them to know what to expect. In the case of a client who might be thinking about taking the stand, a good attorney is going to spend a lot of time talking with them, going over the facts of the case, giving them tips on how a prosecutor might come after them on cross-examination, and making sure they're not surprised or caught off guard. There are other witnesses sometimes who might be very nervous about coming into court and testifying in front of a group of people. And a good lawyer will spend time talking with them, making sure that if they've made other statements to the police, or maybe they've testified in an earlier hearing, they have a copy of those reports or a copy of the transcript so they can review that to make sure that what was written down was accurate, and at times, if necessary, to refresh their memory. Ultimately, a trial is about a search for the truth. And what happens in a courtroom with the dynamics of direct and cross-examination cannot be completely replicated or prepared for in advance. However, spending time to talk to witnesses, allow witnesses to review information, gives them the best chance to be as ready for the trial process as possible. When you're talking about a trial, the opening statement is a very exciting, important part of the trial. Usually it starts with the prosecutor going first, and they lay out a case that's usually trying to be very compelling or damning against the client. When the defense attorney stands up and gives the opening statement, it's his or her chance to tell the story from the other perspective about what happened. And it's important to start getting a jury to look ahead, to see that even though you're going to hear from the prosecution and you're going to hear about this evidence, which might sound bad, you're inviting the jury to keep an open mind and to realize there might be other evidence out there that shows a different version, a different story about what happened. The opening statement, we're not allowed to argue the case just yet. That's later on. That's in arguments after the evidence has been presented. But the opening statement is an opportunity to tell the jury reasonably what we believe the evidence will show. There's two ways to defend a case at jury trial. One is to simply attack the sufficiency of the evidence, because at the end of the day, the prosecutor, the government, has the burden of proof. They have to prove the case against the defendant. And if they don't, under the law, the defendant is entitled to an acquittal and the jury must find him or her not guilty. Sometimes in that role, a defense attorney doesn't have to put on an affirmative defense. They can simply point out why the prosecution has failed to meet their burden. If they're going to employ that strategy, a good defense attorney throughout the entire trial will do what's called death by 1,000 cuts. They will, every chance they have to kind of show why the government's evidence is suspect, why it doesn't meet up to their burden, will go ahead and do that through cross-examination. Maybe it's through pointing out gaps in the evidence. The second kind of way to defend a case at jury trial is to put on an affirmative defense on behalf of the defendant. And that's accomplished depending upon the type of case it is. Sometimes that might be self-defense. Sometimes that might be an alibi. Sometimes it might be showing there's a third party that the police didn't consider as a suspect, that there's evidence that reasonably points towards. Building that affirmative defense can at times be an effective legal strategy because it creates reasonable doubt as to the evidence as it points towards the defendant.